hearing the appeal of Jalla and another against Shell International Trading and Shipping Company and another.
Now, Mr. Seidler, I'm afraid I'm going to take you by surprise. We think as a matter of case management of this hearing, it would be best for us to hear first from Lord Goldsmith on the question of whether we have jurisdiction to hear the additional grounds. The argument has been made that effectively the judge, Mr. Justice Stuart Smith, having held that there was an arguable case of nuisance, and that ruling not having been the subject of an appeal, it's too late effectively to raise the point in front of us. If we can form a view about that, that'll probably help us to determine what the scope of this hearing is going to be and how we should best organise it.
My Lord, yes, my Lord, I should only make this observation for your Lordship's assistance, yes. That on our side we've divided the privilege of advocacy so that my learned friend Mr. Cribb is dealing with that procedural issue.
Right. Now, I appreciate you may need a moment or two to collect your thoughts.
Well, that's fine, my Lord. Of course, we'll do whatever is helpful to the court, and we certainly we thought that the court might approach it on the basis, as the Court of Appeal did, of considering the main issue and then deciding whether it was necessary to hear the respondent's notice. But if your Lordships want to deal with that respondent's notice or the jurisdiction of the respondent's notice first, I'm very happy to do that.
Yes, I mean, if we accept we have jurisdiction, I think we'll then, in all likelihood, proceed in the way you're suggesting, in the way in which the Court of Appeal did. But if we have no jurisdiction to deal with it, then obviously those additional aspects just fall out of the picture.
Right. Well, let me deal with it first straight away then, I think, if I may. So, so what the appellants have said is that the respondent's notice is not open to us, I think, really on three grounds. First of all, they say that Mr. Justice Stuart Smith decided that the nuisance claims were arguable. Secondly, that our procedural objection was not accepted by the Court of Appeal, I think they say, and that we shouldn't be granted permission to appeal it out of time. As to what it means in that sentence, I'll come back to. So the starting point, my lords, as far as I'm concerned, is what the Supreme Court rules say about cross appeals. And that's Rule 25.1 of the Supreme Court rules, which provide that a respondent who wishes to argue that the order appealed from shall be upheld on grounds different from those relied on by the court below must state that clearly in the respondent's written case, which of course we have done. But it goes on importantly, but need not cross appeal. My lords, in my submission, that's actually no different from the position in the Court of Appeal, save that the Supreme Court rules specifically say but need not cross appeal, whereas that's implicit in the rules applicable at the Court of Appeal. So the fundamental point and difference between a cross appeal and a respondent's notice in my submission is precisely that. A respondent's notice is something where you say you want to uphold the decision, well, uphold the order, let me make that clear, uphold the order of the court below, but on different grounds, different or additional grounds. And the fundamental point about saying the order is, my lords, you appeal orders, not reasons. That's always been understood, in my respectful submission, in all the courts of this jurisdiction. And the respondent's notice does not attempt in any way to change the order which was made by the Court of Appeal. So that stands. But we simply say it stands for the reasons that they gave, but it stands also for additional reasons, namely that there isn't a private nuisance in any event because of what we term the land use requirement, and that it doesn't apply because a single event doesn't give rise to a claim in nuisance. It might in Rylance and Fletcher, it might in relation to negligence, but that's not what we're concerned with on this appeal.
Now, the order of the Court of Appeal was simply that the appeal be dismissed.
Exactly. Exactly. And that we're not suggesting that should be changed, and that's the point.
But that would leave in place the order made at first instance at page 221.
We'll just turn that up, my lord. Page 221.
Which, quite a complicated order and declaration.
Oh, it's a declaration, yes, because it dealt
It's a
with the...
declaration that might be said to assume an arguable nuisance and to deal with it in terms of whether it was a continuing nuisance or not.
Because that was the issue.
Yes.
Well, the issue was whether it was continuing nuisance, not actually...
Whether it was an arguable nuisance.
No, not it was a nuisance at all. Because the continuing nuisance point, I'm sorry, the nuisance point only arose at a late stage, as my lords have seen from the chronology. And I can come back to that. But so we're not suggesting that the order of the Court of Appeal should be changed. We're simply saying it remains and it can be upheld on different grounds. Now, there are two additional points. One is that actually, Mr. Justice Stuart Smith didn't decide that the appellant's claims in nuisance were arguable. What he decided was there were arguable claims in tort. And when one looks at it, and I'll take my lords to this, it's actually clear that he was focusing solely on duty of care, on duty of the claim in tort, in negligence.
Well, I'm looking at paragraph 3
of which, my lord?
221, which is very nuisance focused. Paragraph 3 of the order made by Mr. Justice Stuart Smith,
Right.
in which the appeal, I think, came,
Well, they obviously had to.
which is very nuisance focused.
We had to deal with that, obviously, but there was no argument about. Yes, yes, there was no argument, oral argument addressed about this at all, because the issue was only the continuing nuisance, because the nuisance point only arose. On the 10th of September.
Sorry.
I'm sorry, my lord.
Don't you, in substance, want to change paragraph 3 on page 221? Because you want to say that the claims are not arguable for other reasons as well.
Well, my lord, I think all I'm concerned about, I take what my lord says, what we're concerned about is whether or not the appeal should have been allowed or dismissed. Let me just go on to the other ground, because we contested. So I want to make these 2 points. First of all, as I've said, that what Mr. Justice Stuart Smith was concerned about when he said there was an arguable case, and that's in his judgment. I don't know where my lords are taking this from. Just turn up his judgment. It's paragraphs 193 to 194 of his judgment, which is in volume 2, pages 675.
Well, is that the electronic?
It should be page 6775 in the electronic, I believe. No, it's 295 in the electronic.
That's better.
Yep.
Yeah. Where's that? It's in Stuart's paragraph, is it? I've got this here. 193 is on it. So, give me that. So if my lords see the argument which starts at 192, I'm not going to read it aloud, but my lords will see the argument that was raised about whether there was a duty of care, and it goes to 193 about the submissions for and against the existence of a duty of care owed by SASCO, and then talks about direct or vicarious liability, so all negligence concepts. And my lords will see specific reference to duty of care there. And then he reaches the conclusion at 194, I cannot exclude the reasonable prospect that the circumstances upon which the claimants rely may give rise to relevant enforceable duties for the purpose of the law of tort. But my lords will see from the context that plainly what he meant by that was duty of care, i.e. negligence. Because nuisance arose at this very late stage as an attempt to get around limitation.
Yeah. The passage in the paragraph in the order which Lord Briggs has drawn attention to, paragraph 3 on page 221, explains that the declaration is made for the reasons set out in paragraphs 62 to 68. Now, those paragraphs are following a section of the judgment which dealt with the question when damage was first suffered,
yes,
evidently for purposes of limitation. Yes. And the judge then turned, at paragraph 62, to the question, should the limitation period be extended on the basis of continuing nuisance?
Yes.
And that's what he's discussing at 62 to 68. And he concludes at 68 that the limitation period should not be extended by reference to the concept of a continuing nuisance.
Yes.
The claimant's causes of action accrued when each claimant first suffered sufficient damage for the purposes of a claim in nuisance.
Yes. As I said, that was in the context of considering the limitation point, which was at the heart of this.
Yeah. And you're saying that in reality, no cause of action ever accrued for the purposes of a claim in nuisance because the circumstances weren't such as to amount to nuisance as understood in our law.
Well, that's true, my lord. That's true, my lords. But what I'm dealing with at this point is a suggestion that when Mr. Justice Stuart Smith then said, paragraphs 193 to 194 of his judgment, that there was an arguable case in tort that he meant nuisance. He didn't in our respectful submission because the focus had all been on duty of care. Nuisance arose, as I say, at this late stage. But it goes further than that. Because what happened when this point was raised was we believed that it was a proper respondent's notice, and therefore there was no need to cross-appeal. Indeed, we weren't sure what we would be cross-appealing against, because we have to look at what the order of the Court of Appeal is. We're not appealing from or upholding Mr. Justice Stuart Smith's judgment. That's now subsumed, as it were, in the Court of Appeal judgment, and there was nothing in the Court of Appeal's judgment that we wanted to appeal against. Yes. But what had happened at the Court of Appeal level was that the Court of Appeal did allow us to raise the arguments by way of respondent's notice. And I need to ask my lords to turn to tab B11, or volume 2, tab B11, page 863. This is Coulson's letter.
This is a letter from the Court of Appeal's office.
Yes, well, it was actually from Lord. Yes, but it's Lord Justice Coulson who was
Yeah, sure.
as it were, in the lead on this. And what had happened was they said, well, can we have, perhaps we need an initial hearing to deal with this objection. And Lord Justice Coulson's response was, no, you don't, because the arguments that are raised in the respondent's notice are legitimate. And that's in this letter in the third bullet point. Now that's significant, because if we'd been told that it wasn't legitimate, we would have then asked for leave to appeal out of time so as to raise this point. But that didn't happen, because we were told we were actually, what we'd done was legitimate. And therefore it didn't proceed any further. What happened in the Court of Appeal was that they actually decided it wasn't necessary to hear the argument, the substantive argument. They'd taken the view that it was legitimate to raise it. And then, having heard the principal argument, they took the view that the appeal should be dismissed for the grounds that we put forward, and they didn't accept the grounds that were put forward by the appellant, and therefore it wasn't necessary to deal with this additional point. And that's why it doesn't figure in the Court of Appeal's judgment. So we did respond at that stage. It was raised with the Court of Appeal. They told us it was okay. It was not necessary to put anything further in, and that's why we're in the position now where I haven't got an application to amend my out of time because the Court of Appeal said it wasn't necessary.
Well, as we see the email, Lord Justice Coulson, in his judgment, addresses this at page 218. Paragraph 89, he says, I note that there was a procedural dispute
Yes.
About the land user requirement and whether it was properly before this court. The appellants maintain that there was no cross-appeal and submit that in any event the issue wasn't raised before the judge. But it's unnecessary to deal with either the procedural or the substantive arguments, since, if my lords agree, this appeal will be dismissed in any event. So he notes the position being adopted at that stage by Mr. Dutton,
Yes.
And doesn't rule on it.
Yeah, he doesn't go on to say, as he could have done, actually I already ruled on this, and that's the email that I just asked you, my lords, to look at. He might have gone further and said, and what's more, if against that background, if the respondents had asked for permission to appeal that particular, the bit of Mr. Justice Stewart-Smith's judgment my lords have identified, out of time, whatever it may have been, permission is granted or isn't necessary, or whatever he might have said. But that's why, my lords, we respectfully take the permission. This is really a very unmeritorious point. And given the significant arguments that my lords do have to deal with in relation to when a continuing nuisance arises, which is the principal purpose of this appeal, it's unnecessary to get into it. That's why we wondered whether it was necessary to go there at all, as I've said. Can I just would like to just make good the point I made about the timing of this. Yes, so just to get the chronology here, we challenged jurisdiction by an application which, as it happens, is dated the 28th of September 2018. We can provide that or reference to it should my lords want it. One of the points raised in the jurisdictional challenges was the limitation point, i.e. the argument that the claims against the sole remaining anchor defendant, potential anchor defendant, Stasco, were time barred. Now, the appellants raised 4 arguments in response to that. They said there was mistake, deliberate concealment, or the party had been named by mistake, there was deliberate concealment, there was a continuing nuisance and estoppel. My lords will have seen those referred to in our written case, the references at paragraphs 15 to 17. Each of those arguments were considered at two jurisdictional hearings, a one-day hearing in September 2019 and a 2-day hearing in October 2019. Each of them were rejected. But what happened on the 19th of September, which was the hearing day for the first of those dates, a 5th limitation point was raised. We explain this at paragraph 18 of our written case, which is page 151 of the record bundle. And that was the so-called date of damage point, under which the appellant said, it was Mr. Dunning at the time, on his feet, said, oh, well, some of the individuals might actually have suffered actionable damage at a later point in time. My lords would have seen Mr. Justice Stewart Smith said it would have happened within days of the spill. Now, Mr. Justice Stewart Smith noted that that argument didn't form part of their pleaded case, and he said it was safe to conclude that without conducting a mini-trial, I'm quoting his words, actionable damage would have been suffered along most, if not all, of the affected shoreline within weeks rather than months of the spill. My lords have seen that. But he was willing to accept that a small number of individuals might be able to show that they first suffered actionable damage a number of years after the December 2011 spill. And that's at page 330. And that is where we get to the date of damage hearing, which Mrs. Justice O'Farrell dealt with, and my lords have the lengthy, but if I may respectfully say so, very careful judgment of Mrs. Justice O'Farrell now before them. We have always said in the alternative, please may we have leave to appeal on that issue if our respondent's notice doesn't correctly set the position, which Lord Justice Coulson said it did. So that wasn't pursued. Now, when we got to this issue in the Court of Appeal, as I say, they'd heard the substantive argument from both not my learned friend, it was at the time, it was a different counsel, Mr. Sugby? No, it was Dunning. Yeah, and Sugby. He argued it before, no, I'm talking about in the Court of Appeal. It was Mr. Dunning. And therefore it wasn't necessary to rule on the application to make an application out of time because they thought they didn't need to deal with this point at all. But it's never been ruled against us. On the contrary, the Court of Appeal said it doesn't need to be dealt with because your points are competent. Your respondent's notice is acceptable. And the arguments in it are legitimate. So, my lords, I understand why my lords get to this point, but it's really, we would respectfully say, unsatisfactory. We've been told by the Court of Appeal we were entitled to raise the point. We therefore did not make an application to appeal out of time.
But we reserved the position and appeal.
But we've completely reserved the position to do that. And I suppose if my lords, contrary to my submission, say, well, after all, despite what the Court of Appeal said, you shouldn't do this, and therefore you shouldn't be allowed to raise this without having permission to appeal out of time, then that's what I'll have to press that application.
And the additional grounds to which the email referred are the ones that we find, I think it's 767 and following, and the actual grounds begin at 776.
Let me just turn it up, my lord. It's the respondent's notice that we served,
Yep.
which raised the 2 points of no private nuisance if there is not a land user, what we call the land user requirement, and no private nuisance if there's a single isolated event.
Yep.
Those were the 2 points. And they're identical terms to those my lords have them in this court.
Yeah. Yeah, I see.
It doesn't appear that those grounds were advanced before Mr. Justice Stewart Smith. In other words, they didn't form any part of the first instance challenge to jurisdiction.
No, and the reason for that was because nuisance only arose at a late stage at all. I mean, I know it's in the pleading, but nobody paid any attention to nuisance, to be frank, because the issue was whether or not it was a duty of care. That was all the focus, and it was only as a way of avoiding, or hopefully avoiding, the limitation problem that the appellants now, the claimants then, raised the argument of nuisance.
Going back to the form of the judge's order on page 221, and I think the relevant paragraph is paragraph 3, isn't it? Was it procedurally correct in the Court of Appeal to seek to uphold that on the basis of the respondent's notice that we've just looked at, because the arguments were different?
Well, in the Court of Appeal we said we don't accept that it is a nuisance, but if it is, if our respondent's notice point is not right, then it's not a continuing nuisance. And that became the focus of attention. Perhaps I'm misunderstanding my Lord's question.
The order of the judge in paragraph 3 is
Yes.
page 221 and is a declaration in relation to whether there was a continuing nuisance.
Yes.
The additional points to which reference was made in your respondent's notice to the Court of Appeal, it might be said, did not go to supporting that order, paragraph 3.
With respect, my Lord, it does, because if it's not a nuisance at all, it can't be a continuing nuisance.
You're saying it's not inconsistent with it?
Certainly not. No. And given that the fundamental point at the end of the day is the limitation different so that these actions can survive, notwithstanding the dates? And that has to be as nuisance because it can't, it's conceded, it could not continue as negligence. There was an attempt at one stage to say there might be a continuing negligence, but that was dropped in the Court of Appeal. So that's what the issue then became. And we've always said it can't be a continuing nuisance, but we've always said, and in the alternative, we say it's not a nuisance at all for the two reasons we put in the respondent's notice. And if we need permission, please may we have it. Lord Justice Coulson said you don't. So we didn't ask any further, but it's always been live. I mean, that's the point, my lords.
We understand. Thank you, Lord Goldsmith. Mr. Croup.
My Lords, although they are put forward as additional grounds for upholding Justice Stewart Smith's declaration, the two additional grounds are not available to Shell to argue because they are inconsistent not only with that declaration, but also, critically, with other aspects of Justice Stewart Smith's order at first instance. And if Shell wanted to run these points, they were required to seek and obtain permission to cross-appeal. They never made any application to the Court of Appeal below. They've never applied to this court, and it is too late for them to do so now. That is the appellant's position in a nutshell, and I'm going to elaborate on it briefly in a moment. Before I get into the substance, it's important for me to correct the record as to how these points unfolded at first instance. My learned friend says that there was no argument on the arguability of the nuisance claims before Mr. Justice Stewart Smith. That's incorrect. There was argument on the land user requirement. It was developed in Shell's written submissions, which is at bundle page 1630. $1,630. And my lords will see there the heading, Stasco is not liable in nuisance. And this was a submission that was developed with the intention of showing that there was no arguable case as against Stadsco, no real issue to be tried, and that's how it unfolded in the jurisdictional context of that hearing. But my lords will see at paragraph 102, nuisance is a land-based tort, and that submission was developed by reference to Southport and Esso, one of the authorities they rely on before my lordships. This was then pursued further in oral submissions by both parties. The references to those submissions were in footnote 2 to my supplemental written case, but those were inaccurate. The court should have received a letter yesterday giving the correct references. So those are the full references to the oral argument on the land user requirement. Just to show my lords one example, at page 2036 of the bundle, and this is internal page 120, line 8. This is the start of an exchange between my learned friend Lord Goldsmith and Mr. Justice Stuart Smith, which goes on to internal page 125, line 6, addressing the land user requirement and the arguability of the nuisance claims. And I'll just give my lords a moment to read that. So, my lords, the land user requirement was argued in detail orally before Mr. Justice Stuart Smith. It was also pursued in Shell's written submissions. The isolated escape point was not raised before Mr. Justice Stuart Smith. In fact, it also wasn't raised in the respondent's notice before the Court of Appeal. Just to make that good, my lords, the relevant page is page 777 of the bundle. Actually, I should go to 776 first. So 776 are the additional grounds. And they're set out in paragraphs 2 to 5 and then developed. But if my lords read paragraphs 3 to 5, it's all about the land user requirement. And that is why in the court below there were separate skeletons dealing with the continuing nuisance issue for the one part and the land user requirement for the other. So where does this leave us, my lords? It leaves us that there was a detailed argument before Mr. Justice Stuart Smith at the hearing in October 2019, and he would have had that argument well in mind when he gave his judgment and used the references to the law of tort in paragraphs 193 to 194 of his judgment, which I'm going to come on to in a moment. The other point, my lords, just to correct what was said, continuing nuisance was always pleaded by the appellants. This can be seen from their original particulars of claim at page 1071. My lords will see there paragraphs 46 and 47 set out the claim in nuisance. But the key paragraph is paragraph 48 over the page. It is alleged and averred that the spill from the Bonga facilities has caused and continued to cause the claimant's loss and damage. Continues to cause. That's a plea of continuing nuisance. It was developed.
Which paragraph's that, sorry?
Paragraph 48 on
48.
page 1072.
Thank you.
So, my lords, that's the background. At first instance, Stasco argued that there was no arguable claim against it in nuisance. And that issue was one of the arguments that Stasco pursued as to why there was no arguable claim against it in tort. And Mr. Justice Stuart Smith dealt with these arguments at at page 294 of the bundle. And I start there, my lords, because it's important to note the heading, do the draft amended particulars of claim disclose the basis for a claim against Stasco that has reasonable prospects of success. So Stuart Smith is dealing here, Justice Stuart Smith is dealing here with all of the claims against Stasco. He sets out the arguments, and then he sets out his reasoning in paragraphs 193 and 194. It's compressed, but Mr. Justice Stuart Smith is dealing with the claimant's claims compendiously. He says the claims give rise to issues that should or cannot be resolved in the context of interim applications, and that he cannot exclude the reasonable prospect of the claim of success for the claims. And my lords, that reasoning is just as applicable to the nuisance claims as to the negligence claims. And tellingly, my lords, Stuart Smith refers to the law of tort 3 times. But in any event, my lords, the crucial aspect is the order, which can be found at page 220. And on page 221, my lords, see the declaration. I do say that that declaration presupposes the arguability of the claims in nuisance. It talks about the nuisance as alleged by the claimants. Equally important to me, my lords, are paragraphs 4, 6, and 8. Because in paragraphs 4, 6, and 8, it's a complex architecture, but the judge allows the claimant's amendment applications and dismisses the defendant's jurisdiction challenges for any claimants who are not time-barred. And I'd ask my lords to focus in particular on paragraph 8.1, where Justice Stuart Smith holds that the court has and shall exercise its jurisdiction to try the claims against both Stasco and Snepco. Now, that order presupposes the arguability of the nuisance claims. It doesn't carve them out. So Shell are simply wrong to submit that Stuart Smith did not decide that issue. He decided that issue, and he made his declaration in paragraph 3 and his order in paragraph 8.1 on that basis.
Did I understand you, though, to accept that there was nothing about the isolated escape being discussed in Stuart Smith's judgment? It was simply a land user?
Yes, the isolated escape point was not taken by Shell at first instance. However, having not taken the point at first instance, and Stuart Smith having held that the nuisance claims were arguable and made an order on that basis, it is too late for Shell to reopen that issue.
Or before this court?
Before this court or before any court, having failed to challenge the order which presupposes the arguability of the nuisance claims, shall are bound by that decision until trial.
And by until trial, you mean that they can challenge it at trial?
Yeah.
Yes, they can argue that there is no claim against them in nuisance at trial.
And they can challenge it by any process of case management and pleading and preparation before the trial, but it only comes up for grabs at trial.
Yes, I think that's right.
The ability to challenge at trial assumes a case management process that enables you to pursue such a challenge.
Yes, my lord. I think what I'm saying is it's not open now for Shell to seek to determine the issue summarily.
At trial, the issue will be determined on its substance. All that's been determined thus far is whether it was arguable or not, but you say the judge said it was arguable, sufficient to merit a trial on the substantive merits of the point.
The judge will hear evidence, make findings of fact, and determine the issues of law against the evidence in the ordinary way.
At trial, he won't be ruling on is this arguable or not. He'll be ruling is it right or not.
Yes, just so, my lord.
What the court has ruled is it has jurisdiction to hear the whole case, in relation to which an arguable case was an essential plank in the court's assumption of jurisdiction.
Yes, subject to the limitation issue, my lord.
Yes,
the court has found that it has jurisdiction subject to limitation, and the conclusion on jurisdiction presupposes the arguability of the nuisance claims, which aren't carved out by the learned judge's order at first instance. And because of that, my lord, if Shell did want to reopen the arguability of the nuisance issue, they had to cross-appeal, and that required leave, which has never been obtained.
Well, Lord Goldsmith took us to the email setting out Lord Justice Coulson's case management directions, and it seems from that that a preliminary hearing had been requested, presumably on behalf of the claimants, into whether, I presume, it was open to respondents to advance the arguments they were setting out in their respondents' notice.
Yes, my lord. And following the exchange of correspondence, Lord Justice Coulson gave the directions that he gave in his emails of September 2020. But that wasn't the end of the story. My lords, I think, have seen what Lord Justice Coulson said in his judgment, which is on page 218.
Yeah. It doesn't sit terribly happily with the email, where this may be, well, what both the claimants and respondents were told was that the arguments advanced in the respondent's notice are legitimate.
Well, that was a direction, my lord, given by one Lord Justice of Appeal on paper. There was then a hearing. It might be helpful to start, actually, with how the hearing opened, and that's at page 881 of the bundle. And I'd ask my lords to read lines 3 to 10 of the first page. And Lord Justice Lewison there indicated that the Court of Appeal would hear the procedural objection depending on its conclusion on the main issue of the appeal. So Lord Justice Lewison wasn't proceeding on the basis that this was decided.
Can I ask, was there a skeleton, were there skeleton arguments filed which went to debating the procedural points?
Yes, my lord. Allow me to find the reference, one moment. Yes, I think it would be 843. This is my supplementary skeleton below. And the objection to the additional grounds, at that time just the land user requirement, is set out on 845 in paragraphs 9 through to 22 on page 848. So the procedural objection was developed in detail in writing before the court below. The hearing begins and Lord Justice Lewison indicates that it's open to argument.
And presumably in that argument, Lord Goldsmith would have pointed to the email that he'd received, that their side had received, and Lord Justice Lewison would have to take a view on that, much as we're having to take a view. So it's a bit neutral, isn't it, that opening paragraph?
The procedural objection itself wasn't argued. What I rely on for the purposes of my argument is Lord Justice Lewison indicating that if it arose, we would be permitted to advance the objection just as I am now. He didn't decide the objection in my favour.
Yeah. So in a sense, it's neutral.
In a sense, it's neutral. What perhaps is more important is paragraphs 88 to 90 of Lord Justice Coulson's judgment, agreed with by the other two Lords Justices below. And in 89, this is on 218 of the bundle. At 89, he notes the procedural dispute and whether it was properly before the court. And he holds that it's unnecessary to deal with the procedural or substantive arguments, i.e., he is leaving open the procedural objection that I'm advancing before my lords today. So where that leaves us is with an order of the court at first instance, which has never been appealed against, no application made to Mr. Justice Stuart Smith or to the Court of Appeal, no application to my lords. One would expect, if there was doubt about this point, and there must have been doubt about this point in light of the submissions advanced, that an application for leave would have been made ex abundanti cautela, out of an abundance of caution. Shell haven't done that, my lords, and they've therefore taken the risk. But the short point, my lords, is if my lords are with me that this is a cross appeal, then that required permission to be advanced below, and it requires permission to be advanced for my lords. And there is no permission. And having failed to seek permission, Shell are bound. If Shell had sought permission below, and permission had been refused, they would not have been in a position to renew that application before my lords. And it would be wrong in principle for Shell to be in a better position where no application for leave has ever been made. And given what is suggested by my learned friend today, is that he now make an application massively out of time for leave to cross-appeal. My lords, if you were hearing an application for leave to cross-appeal massively out of time, one would normally expect detailed evidence and very good reasons put forwards as to why it should be granted. My lords, nothing from Shell on that front. We explained to them that this was a cross-appeal, not a respondent's notice point, as long ago as September 2020 when we filed our submissions on this. And finally, my lords, the procedural rules exist for a reason. The requirement of permission operates as a filter to ensure that the appellate court's time is only spent addressing issues which are worthy of its consideration. So Shell's attempt to force their cross-appeal into this hearing without leave, out of time, by trying to disguise it as additional grounds, is an inappropriate approach to appellate litigation. And the court should not countenance that. And to do so, one, would set a very unfortunate precedent, and two, would prejudice my clients by seeking to rewrite the conclusion of Justice Stuart Smith on jurisdiction, because the court did hold that jurisdiction had been established subject to the question of limitation. And Shell should not now be allowed to go round that out of time. Those are my submissions, my lords.
Thank you, Mr. Cole. Anything to add, Lord Goldsmith?
Lord, just a couple of things, if I may. First of all, I would like to draw the court's attention to page 862 of the bundle, the electronic record, which is the second page of a letter from Shell's lawyers responding to what my learned friend's solicitors have said. The letter that they sent is at page 294, which is a letter of the 16th of September. Which is where, as my Lord Reed anticipated, the application for a preliminary hearing was made by the claimant, the appellant.
Lord Goldsmith, I'm very sorry, I missed that page reference to the appellant's letter.
The appellant's letter is at page 294.
860.
No, sorry, it's 860. Sorry, there's so many page numbers on these documents. I do apologise. 860. I'm sorry. Sorry, 860. Letter of the 16th of September.
Right.
I'm not going to read it. My lords can see what it said. Let's have a short hearing, please. They said. And we responded to that on page, not 296 at all, it's 861. That's why I got that reference wrong as well by using the wrong number. 861 is the response from Shell's lawyers on the 21st of September 2020. And if my lords will see on the second page of that letter, having argued why we say it's a proper respondent's notice because it's not seeking to overturn the order, it's seeking to give additional reasons why what Justice Stuart Smith said was right. I'll come back to that point. We then said, even if the Court of Appeal were to consider that the filing of the respondent's notice was not the proper procedural approach, the respondents could still request that the respondent's notice be amended and treated as a notice of appeal in order to regularise the position. Any such application could be dealt with over the hearing. And then if we go to, please, if we can go to the agreed statement of facts and issues, to which my own friend hasn't taken the court, paragraph 79.2, which is on page 410 of the bundle. Having set out the land user requirement issue, starting at page 409 at paragraph 79, 79.2, we say, if it's held that the land use requirement wasn't validly raised, and in circumstances where the Court of Appeal ruled that the arguments advanced in the respondent's notice are illegitimate, does the Supreme Court grant permission out of time for the land use requirement issue to be heard by way of cross appeal? So it's quite wrong to say we haven't asked. We have consistently said if we need to, we seek permission to cross appeal. As to the arguments raised by my learned friend that the material on it, all the material is before the court. It's all there. So no prejudice other than they were not able to get away with knocking a point out that they're obviously worried about out. And given the answers that my learned friend gave to the President, as I understand it, he accepts that the issue of whether there is a nuisance would be something that the trial judge would have to determine. And that leads to this possibility, that this court, the Supreme Court, will have decided issues in relation to continuing nuisance, getting very close to the question of nuisance, but not that point as to whether the land use requirement is there. The matter then goes to trial, it's decided, and then it has to come all the way back up here on land use requirement from one side or another. As a case management, it makes no sense at all, and there's no prejudice, and it's really unacceptable. Now, we've done all we can do. We've raised this. We thought it was acceptable to do what we've done. We've raised it openly. There's no hiding anything. We've raised it openly. Lord Justice Coulson said, yes, that's legitimate. What are we supposed to do? Say, no, you're wrong, it's not legitimate? Mr. Justice Lewison, Lord Justice Lewison could have said, well, I've seen what Lord Justice Coulson said, but I don't agree, so we want this to be argued. They didn't want it to be argued. Lords, I'm not sure there's more I can say. Your Lordships have got my submissions.
Very much. We'll adjourn for a short time to consider submissions. We're satisfied that the land user point was argued before the judge, and that the respondents also raised the matter before the Court of Appeal in their skeleton argument. They may have adopted an inappropriate procedure, but the Court of Appeal is a master of its own procedure, and it accepted that the matter was legitimately raised by the respondent's notice. So in those circumstances, we're satisfied that there is no jurisdictional bar to the issue being raised before this court. The single act point wasn't argued below, but it's open to the respondents to seek to raise it before us, and again, there is no jurisdictional bar. Both seem to us to be properly understood as cross-appeal points, and therefore permission to argue them needs to be granted by this court. What we propose to do is hear the argument on the points de bene esse, and if, having heard it, it's appropriate for us to grant permission, then we will do so.
Lord, I'm obliged. May I tell my lords that these points always were going to be argued by Dr. Blake, so that will happen. But tomorrow, I'm already getting a little bit nervous about time.
Yes.
We take what your lordship says about needing to deal with this, and your lordships will hear the argument de bene esse and then decide whether we should have permission. So I understand.
My Lord,
Yes.
likewise, if it's of assistance, I'm going to take, with your Lordship's permission, the point about continuing nuisance, and then my learned junior, Miss Hawker, will seek to assist the court on the question of the land user requirement,
Yes.
and my learned junior, Mr. Cribb, will follow on the isolated escape issue. My Lord, the issue between the parties as regards continuing nuisance, is this. Can a defendant, in legal principle, be continuously liable for a continuing interference where its acts have caused a substantial interference with the claimant's property, and that substantial interference continues? Or does there also have to be fresh wrongdoing or continued control on the defendant's part for there to be a continuing liability for the continuing interference with the claimant's land caused by the defendant's original wrong? Those are the issues. It's whether you need fresh wrongdoing or continued control, as my learned friends say, or whether, as we say, neither repeated wrongdoing nor continued control on the part of the defendant is actually required on the facts of this case and in any case like this. And, my Lord, in order to make that good, I first need to set out the legal background very briefly in terms of the elements of nuisance, and in particular, the question of causation in nuisance. And I also would like to say a word about fault in the law of nuisance, because those submissions about causation and fault are critical to what I need to say about there being no need for continuing wrongdoing or continuing control. So, my Lords, there are three constituent elements of the law of nuisance, and only one of them is really of concern to us on this appeal. And it's the first one, which is the creation or allowance of an act or a state of affairs by which the defendant causes something. That's the first element. A creation or allowance of an act or state of affairs by which the defendant causes something. The second element is that what needs to be caused is a substantial interference with the claimant's reasonable enjoyment of his or her land. And the third element is the land interfered with needs to be one in respect of which the claimant has exclusive possession. And if your Lordships need authority for that, it's in Lawrence and Fentigers in this case at page 330. 3330. And it's in the speech of Lord Newburgh of Abbotsbury between letters F and G on page 330. This is where I got my definition from roughly. A nuisance can be defined, albeit in general terms, as an action or sometimes a failure to act on the part of the defendant which is not otherwise authorised and which causes an interference with the claimant's reasonable enjoyment of his land, or to use a slightly different formulation, which unduly interferes with the claimant's enjoyment of his land. So the causation is the element that links the state of affairs with the substantial interference. And, my Lord, there are two things about the first limb of that, the creation or allowance of a state of affairs by the defendant which causes something. There's two two things about that first limb that's important to draw out for the purposes of this appeal. The first is that in the first limb, the act or the state of affairs, the creation or allowance of which gives rise to a substantial interference, may well be, in fact, usually is, completely legal, perfectly legal. In fact, in many cases, it's more than legal, it's perfectly desirable. It's things like growing trees or playing cricket. And that itself highlights that the essence of nuisance is not the conduct of the defendant. It's the harm to the claimant. And indeed, my lord, the clue is in the word. The word nuisance, like the word annoy, is connected with the Latin word nocumentum, which means harm. The essence of nuisance is harm, and that's one of the distinctions between nuisance and trespass, which is actionable per se, and that's why nuisance historically has been an action on the case. There's a couple of useful authorities which illustrate this, and the first is Robertson Reed, which is at page 5138. Which goes as far back as 1812. And in that case, highway surveyors undermined a wall adjoining a highway, which fell more than 3 months after the work that they did. And 3 months was the relevant statutory limitation period. And my lord, the short judgment of Chief Justice Lord Ellenborough is on page 5139. It's only a few lines, where he says it's sufficient that the action was brought within 3 months after the wall fell, for that is the gravamen. The consequential damage is the cause of action in this case. If this had been trespass, the action must have been brought within 3 months after the act of trespass complained of, but being an action on the case, with the consequential damage, it could not have been brought till the specific wrong had been suffered. That only happened within 3 months before the action brought. And my lord, a slightly more recent acknowledgement that that is the law, that the gravamen of nuisance is in the harm, is in Sedley, Denfield and O'Callaghan, which is at page 5184. And my lord, we'll come back to this in a moment, but the passage for present purposes is in the middle of page 896, or just above halfway, page 896.
And the electronic page?
My lord, the judgment page.
The electronic page.
The electronic page, my lord, is 5200.
Thank you.
My lord, it's 12 lines down, where Lord Atkins says, it is probably strictly correct to say that as long as the offending condition is confined to the defendant's own land, without causing damage, it is not a nuisance, though it may threaten to become a nuisance. But where damage has accrued, the nuisance has been caused. And my lord, we say it makes sense for interference with the claimant's land to be the element that dictates whether the nuisance is continuing or not, or whether the nuisance has started or not, or whether it exists or not, because it's the claimant's use or enjoyment of its land which the tort is intended to protect. And my lord, in Sedley Denfield, what happened was that the source of a nuisance source of the nuisance was a guard being put on top of a pipe rather than in front of it, which, like Appellants said, made the guard useless. It was just put on top of the pipe, it didn't block anything. But that wasn't the nuisance itself.
Well, there are numerous statements in the judgments which suggest that was the nuisance. I mean, the odd thing about this case is you see the nuisance as being identified at different places in the judgments as something different.
My Lord, what I'm going to submit to your Lordships, with your Lordship's permission, is that there has historically been a confusion between an abatement of the source of the nuisance, which is a very important thing in certain situations, not ours, and remediation of the actual harm, which is quite different. But, my Lord, I think what Viscount says was that putting the guard on the top was useless. It wasn't the pipe and the guard and their relationship that was the nuisance. The nuisance was the flooding that ensued as a result of that useless act. And that was continuing. It was a process. It happened every day that the flooding occurred. So, my Lord, that's the first thing that we say is worth drawing out of the first limb of the definition of nuisance that Lord Neuberger uses.
Can I just ask a rather basic question? Are we operating, first of all, on the assumption that the Nigerian law of limitation, or whose law of limitation, first of all, are we applying?
My Lord, I think for present purposes, we should be thinking of our law of limitation.
And so is the relevance of this that the limitation period runs from the date when the cause of action accrued?
My Lord, I'm thinking about my previous answer. It may be the Nigerian law of limitation, but this court, that will apply at the trial, but this court can only work on the basis that the date for whichever limitation period is relevant runs from when the cause of action accrues.
Yes, and so the relevance of this entire topic is that you have to establish that a fresh cause of action accrues every day.
Absolutely, my Lord.
Yeah.
My Lord, that we accept is the challenge that we face.
Or at any rate, what was accruing to the claimants to within a date less than 6 years before the proceedings were relevantly commenced.
My Lord, the position is that the applicable limitation statutes Nigerian, the Nigerian law of tort has been assumed to be the same as the English law throughout these proceedings. Yeah. But, my Lord, perhaps the more significant point is that, my Lord, the President has with respect, put his finger precisely on the point, which is that this appeal is about the accrual of the cause of action in nuisance, not about limitation. Limitation is a knock-on effect. It's about when the cause of action accrues in a case like this.
Can I just ask you then, as you've raised Sedley-Denfield, let's assume that in Sedley-Denfield there was flooding, but the flooding had stopped. Do you say that the nuisance continues because there is flood water, the same flood water, on the claimant's property? Does it run day by day until the flood has been removed?
Yes. The short answer to my Lord's question is yes. For so long as the floodwater is causing harm to the claimant's land, the nuisance is continuing, irrespective of what's happened on the defendant's land.
So I just want to be absolutely clear. Let's just assume that there is no further floodwater flooding onto the claimant's land.
Yes.
So you've had effectively a flood.
Yes.
You say that so long as there is floodwater on the claimant's land, there is an accrual of a cause of action day by day until the last inch of floodwater is removed. Is that correct?
As long as it continues to cause damage, yes.
Yes. Albeit the same damage. It's not fresh damage, it's the same damage, isn't it?
Well, Tuesday's damage, my lord, is similar to Monday's damage, but it's different because it's happening on Tuesday and it's damaging different crops, different shrines, different bits of land.
If a house was flooded on day one, or perhaps we might say burnt down on day one, are you suggesting that on day two it's different damage?
My lord, if that's a factual question. Fire may be in a different category. Fire may be in a different category.
Well, let's take floodwater then. The house is flooded on day one and is uninhabitable. Are you suggesting that it's when the same uninhabitability because of the flooding is still there on day 10, that's fresh damage on day 10?
If water stays on the property and causes new damage because it's continuing, so it's not the same as yesterday's damage, it's damage to different parts, then the water may, for instance, continue to erode woodwork, which is what we say happened in Sedley Denfield. But, my lord...
I think I'm putting to you that there isn't any further. It's the same damage, it's the same flooding. Do you still say that the day-by-day continuation of the same damage constitutes continuing nuisance?
My lord, not if it's the same damage, but it will not be the same damage. My first answer is that the focus has got to be on the claimant's land, and the use or enjoyment of that land is interfered with. Each day the floodwater remains, and each day the floodwater remains, because water stays on the land in a way that fire will do for much less time, it will do different damage, it will rot different wood, it will permeate different areas. But, my lord, I wonder if we might come back to that when we look at Sedley Denfield in a little more detail.
Yeah, that's absolutely fine. I'd just like to be clear whether on the facts of this case at some stage it is being alleged that there is different damage of that kind, or whether the damage... So, in other words, is it ever-changing damage, or is it damage that is the same?
My lord,
in relation to the oil?
My lord, I'm going to, with your lordship's permission, I might take a little moment to think about that and then come back to it when I come to Sedley Denfield. We have two, when I finally get there, we have two cases that we say are those which are entitled to be at the forefront of your lordship's thinking. One is Sedley Denfield and the other one is a case called Darley Main Colliery against Mitchell. So I will look at those cases in a little more detail. The other one, of course, is Delaware Mansions.
If I could just interject, it would also be, I think, helpful to us to have some sense of the reality of what we're dealing with. As I understand it, we're now concerned only with two individuals, Mr. Jalla and Mr. Kujor, and we don't know anything about them, whether they're farmers or fishermen, whether they collect shellfish from rocks or fish in the sea or grow crops or have a herd of goats or whatever it might be. So we don't really know what we're dealing with at all.
My Lord, I will also come back to the individuals concerned and how it impacts those 27,000 odd other people who are awaiting the outcome of your lordship's deliberations on this, because
we are only concerned with two individuals.
We are only concerned on this appeal with two individuals.
I'm so sorry, if you're still answering, please finish. But I'm conscious you want to move on, but just before we move on from the flooding point raised by Lord Burrows, I was trying to think how that would work. Suppose you have a flood that remains in place in a house for a period of time. one might have thought that you could sue as soon as you see my house has been flooded and get compensation for the loss from that flood, even though the rot in the wood may only set in 10 days later or something like that. But your answer seemed to suggest that you could only sue for that rotted wood, which happens in 10 days, after 10 days after the flood has occurred, because that damage hasn't occurred until then. So I just wondered how realistic that was. And is that your position, that if it is a case of damage occurring afresh each time, then you need a new writ each time to claim for that damage, because you don't have an accrued cause of action, it being an action on the case, for each of those elements of the loss until they've actually been suffered?
My Lord, I'm going to think about that one too. Okay. I think the answer is, in practice, one would add subsequent loss, subsequent damage, if one did sue on the first episode of damage. One would simply add it on. And that is that the facts that your Lordship are thinking about are similar to Darley Main Colliery.
All right. Well, deal with the point as and when you see fit. I just wanted to raise it at this stage.
Thank you, Mary. My Lord, I said that there were two things to take from the first limit of the definition of nuisance. One was that it's the harm to the claimant that's the essence of the nuisance. The other one is more nuanced, and it's about the causation requirement. Because having looked at all these cases, it looks like the causation requirement, perhaps by necessity, is treated differently in cases depending on whether the claimant's created the nuisance or has just allowed that nuisance to be there. When the defendant creates the nuisance themselves, the position is straightforward. If a party commits an act or creates a state of affairs which causes a substantial interference with the claimant's reasonable enjoyment of its land, then it's straightforward that the defendant should be liable. In fact, McBride and Bagshaw, in their book in their chapter on nuisance, say it's perfectly straightforward when there's a single act which creates a nuisance. So creating a nuisance is things like watching and besetting the claimant's property, so the picketing cases, or the defendant itself creating a viewing platform which overlooks the claimant's residential property. That's an act that they've done themselves. And our case is a creation case. Shall have created this nuisance. But the position is much more nuanced when the defendant's liability is founded on allowing a nuisance. And Sedley Denfield is an allowing case, and it's dealt with there. My Lord, it's the case is at is in the authorities. At page 5184. And the passage is at the bottom of page 904 of the report, which is page 5208 of the authorities. Where Lord Wright, in 12 lines from the bottom of page 5208, starts with making the point I've just made. If the defendant by himself, or those for whom he's responsible, has created what constitutes a nuisance, and if it causes damage, the difficulty now being considered does not arise. So, straightforward creation, no problem. But he may have taken over the nuisance, ready-made as it were, when he acquired the property, or the nuisance may be due to a latent defect or to the act of a trespasser or stranger, as it was in Sedley Denfield. Then he's not liable, unless he continued or adopted the nuisance, or more accurately, did not without undue delay remedy it, when he became aware of it, or with ordinary and reasonable care, should have become aware of it. And my lords, that difference is also discussed in the Court of Appeal case more recently of Williams and Network Rail. The case is on page 5002. And the passage is at paragraph 44 of the judgment of the Master of the Rolls, Terence Etherton, and it's page 5015. Paragraph 44, the Master of the Rolls says, fourthly, nuisance may be caused by inaction or omission, as well as by some positive activity. An occupier will be liable for continuing a nuisance created by another if, with knowledge or presumed knowledge of its existence, he or she fails to take reasonable means to bring it to an end when they had ample time to do so. An occupier will also be liable if he or she fails to act with reasonable prudence to remove a hazard, whether natural or man-made, on their land, for which he or she was aware and where it was foreseeable that it would risk damaging their neighbour's land. Now, there's two things to note about these allowing cases. The first is that it's only in these allowing cases that a consideration of a failure to abate arises. Where the defendant creates the nuisance itself, then the defendant's already liable, so no abatement of the source of the nuisance is really relevant. And the reason for that is that the liability for failing to abate flows from the fact that the owner or occupier of land has it within its power to prevent the interference with the claimant's land and doesn't do so. So in Sedley Denfield, it was failing to rectify a grate installed wrongly by a trespasser. Brother Decker knew all about it because he inspected it every few months. And the second thing to note about these allowing cases is that, and this picks up the point my Lord Briggs made, was that the duty of abatement actually relates to the source of the nuisance. It's a duty in allowing cases, which makes the defendant liable, to prevent the hazard on the defendant's land from manifesting into a nuisance by causing interference with the claimant's land, and where the defendant fails to do that, they're liable in nuisance, even though they're not responsible for its creation. And some cases do talk of abating the nuisance, but that's shorthand which is misleading. The nuisance is really the interference with the claimant's land. And what they mean is abating the source of the nuisance. Remediation, which is clearing up the harm itself, is quite a different thing. So if you don't create the nuisance yourself, in terms of causation, if you just allow it, your liability depends on the reasonableness of abatement of the nuisance. So, where the defendant could reasonably have abated the nuisance, abated the source of the nuisance, but hasn't done so, Sedley Denfield, they'll be liable. Where the defendant couldn't have reasonably prevented the interference, they will not be liable. And the authority for that is a case called Green and Lord Somerleyton, which is on page 3684, which is a flooding case. And the passage is at page 3704. In paragraph 78, Lord Justice Jonathan Parker refers to leaking and a case where the court held an occupier of land owes a general duty of care to neighbouring occupiers in relation to a hazard occurring on his land, whether natural or man-made, and then cites Lord Justice McGaw in Goldman and Hargrave, or Lord Justice McGaw in Leakey, citing Goldman and Hargrave, saying the nature and extent of the duties explained in the judgment in Goldman and Hargrave. The duty is a duty to do that which is reasonable in all the circumstances. And then on page 3706, in paragraph 85, Lord Justice Jonathan Parker cites Jones and Portsmouth, which is the related principle. It's not just about a question of whether it's reasonable in all the circumstances, but in particular, it can be a question of whether there is control over the hazard. Jones and Portsmouth, in my view, the basis for the liability of an occupier for a nuisance on his land is not his occupation as such. Rather, it is that by virtue of his occupation, an occupier usually has it in his power to take the measures that are necessary to prevent or eliminate the nuisance. He has sufficient control over the hazard which constitutes the nuisance for it to be reasonable to make him liable for the foreseeable consequences of his failure to exercise that control so as to remove the hazard, source of the nuisance. And then the disposal of the case is in paragraph 107 on page 3713. I needn't take your lordships to that in detail, but it turns on the facts. And it turns on the facts in particular because for various reasons which arose in that case, it wasn't reasonable for the defendant to have prevented the interference with the claimant's land by abating the source of the nuisance. So in creation cases, it's straightforward. Of course, there's causation, but in allowing cases, there are touchstones of reasonableness and control. Now, what that means for our appeal, my lords, is fundamental, because it makes Shell's closing of the leaking pipe within 6 hours legally insignificant, because any stress on it is applying a concept from allowing cases to what's undoubtedly a creation case. On the claimant's case, both Shell entities created the nuisance comprised by this spill by extracting the oil and allowing leakage during the loading operation. It didn't occur naturally. It wasn't created by anyone else. They created the nuisance. So the question of them having a liability arising out of a power to abate its source but not exercising the power doesn't really arise. Furthermore, any stress on the closing off of that pipe is conflating the source of the nuisance with the nuisance itself. My lords, Shell's liability doesn't arise from any failure to abate the source of the nuisance. Nobody's alleging that. What we say is their liability arises from the creation of the nuisance. That nuisance caused continuing interference with the claimant's enjoyment of its land when, but only when, the oil impacted the claimant's land well after the pipe had been closed off. My lord, what we say, therefore, about the central thesis of the respondent is that they've fallen into error in their detailed analysis because they've misunderstood the place of control in the law of nuisance. Where the defendant creates the source by picketing, leaking oil, it's obviously within their control to prevent it. Where a third party creates the hazard or it occurs naturally, then issues of control and reasonableness arise. And there are two very long-established cases which illustrate that, and also illustrate that continuing control is not a prerequisite of liability for nuisance in a creation case. And of the two old cases, the first is of a case called Rosewell and Pryor, which is page 5148. The defendant was liable for the continuance of a nuisance created by erecting an obstruction on land which interfered with ancient lights, even after he'd subleased the property. My Lord, the case report reads, in an action upon the case for that the plaintiff being seized of an ancient house and lights the defendant had erected, etc., whereby they were stopped, there was a formal recovery for this erection, and this action was for the continuance. And the case was, tenant for years erected a nuisance and afterwards made an underlease to JS. The question was whether, after recovery against the first tenant for years for the erection, an action would lie against him for the continuance after he had made an underlease. Answer, it lies, for he transferred it with the original wrong and his demise affirms the continuance of it. It's a short report, and we can't find any longer report. But the second case
doesn't lie very happily with your submission, does it? I mean, the analysis, albeit highly compressed, is all about whether his conduct in letting the property and taking a rent from it having been constructed in that condition, puts him in the frame as a continuer. Whereas you say, well, he was liable as a creator. It really doesn't matter whether he continued it or not.
No, my Lord, I'm using this authority to say that continuing control is not a prerequisite of liability for nuisance in a creation case. My Lord, it's too compressed, but it's about to be slightly expanded. Okay. Because in the second case, which is Thompson and Gibson at page 5448, there are quotations from the judgment of Lord Holt in Rosewell and Pryor, the case we've just looked at, which don't appear in the original report. Indeed, I didn't even know it was Lord Holt. But Thompson and Gibson is page 5448, which was decided by the Court of Exchequer. And in that case, the defendants had superintended and directed the erection of a building on land which they didn't own. And the building excluded the public from a part of the space on which the claimant's market was lawfully held. The defendants were found liable for the continuing nuisance, even though they had no right to enter on the land to remove the offending building. And my Lord, at the bottom of page 549, Baron Park asks 5449.
5449.
5449.
Yep.
Baron Park asks the question, is he who originally erects a wall by which ancient lights are obstructed to pay damage for the loss of the light for the first day only? Or does he not continue liable so long as the consequences of his own wrongful act continue and bound to pay damages for the whole time? And my Lord, there may be an echo in Baron Park's question of the question that my Lord Burrows asked me a few moments ago. Does he pay damage for the loss of the light for the first day, or does he not continue liable so long as the consequences of his own wrongful act continue and bound to pay damages for the whole time? It's the consequences of the wrongful act, not the wrongful act itself. And then, if your Lordship's eyes drop down to halfway down page 5450, Rosewell and Pryor, the case we've just looked at, is cited, but in expanded form. Baron Park, he must have had a report that we haven't got. He says, in the case of Rosewell and Pryor, which was an action against the defendant who erected an obstruction to the ancient lights of the plaintiff and then aliened, Lord Holt lays it down that it is a fundamental principle in law and reason that he that does the first wrong shall answer for all consequential damages. Also, at the bottom of that report, the last 5 lines is an is a point that echoes those raised by my learned friends for the respondents. It was also said the defendants could not now remove the nuisance themselves without being guilty of a trespass to the corporation, that it would be hard to make them liable. But that's a consequence of their own original wrong, and they cannot be permitted to excuse themselves from paying damages for the injury it causes by showing their inability to remove it without exposing themselves to another action. We're therefore of opinion the action is maintainable. Now, my lord, in both these cases, in neither case where the nuisance was created by the defendant, was there a lack of control to abate the source of the nuisance, an issue which prevented liability arising. In each of these two cases, which have stood the test of time, the nuisance was created by the defendant. The creator of the nuisance, the defendant, then lost control, but was still liable. So there was no requirement of continuing control. Of course, there are cases on the other side of the line, like Jones and Portsmouth, where, because that was an allowing case, control over the source of nuisance was capable of determining liability because it wasn't reasonable to abate the source of the nuisance because there wasn't the control. But that's not our case.
I mean, isn't that further supported by the fact, if we think about the facts of Sedley Denfield, the claimant can always sue the creator of the nuisance, in that case a trespasser, even though plainly that trespasser has no control over the nuisance that has already been created.
Absolutely.
Yeah.
Yes.
That's easy enough, and this case also is straightforward because it's this is a case about continuing damage. But if you're, I was thinking aloud that if the argument is that a fresh cause of action is accruing day by day, it might be said that it's rather odd that a cause of action can accrue against a defendant which the defendant has no entitlement to prevent accruing.
Yes, that's the respondent.
I mean, he has no entitlement to stop himself from wrongdoing. That's rather paradoxical.
It's the consequences of his wrong. He had the ability to prevent to abate the source of the nuisance in the first place. On the facts of this case, there was oil leaking into the sea for 6 hours. It could have been stopped after 6 minutes. It may have been very different. So yes, but what those two cases say is, well, that's a consequence of the original wrong.
Well, there we are. You say, for example, I don't know. Say the floodwater, for example, in Sedley Denfield. We don't need to tie ourselves to the facts of Sedley Denfield, but just say there is floodwater which has been caused by flooding from adjacent land, and the argument you're presenting is, so long as the floodwater remains in situ, a fresh cause of action accrues every day, and clearly the adjoining proprietor who has caused the flooding has no entitlement to enter into the claimant's land to remove the floodwater by using pumps or whatever. And you say that even if he offers to come in and pump the water out, the defendant, of course, is entitled to refuse him permission to do that, and there will continue to be a cause of action accruing every day against the claimant.
My Lord, can I answer that question by saying, in this case, your Lordships have seen our particulars of claim, we are begging Shell to remediate. We are begging them.
Yeah, but that doesn't It doesn't address...
Not a question of principle. My Lord, in principle we say it's covered by the fundamental rule laid down by Lord Holt. It's a fundamental principle in law and reason that he does the first wrong shall answer for all consequential damages.
That doesn't tell us when... Sorry.
You know, but that's the familiar... That's a different point. I mean, obviously, you have to... if you're a tortfeasor, you're liable for consequential damage as well as the immediate damage.
My Lord, it's always subject to a duty to mitigate. A claimant always has a duty to mitigate. It may be, on facts like our case, that the duty to mitigate is best discharged by inviting Shell onto the land, which has happened, and saying, please remediate and clear up. But I think, with respect, my Lord, the President, instincts, legal instincts here, are reflected in the duty to mitigate, which lies on every claimant. And that may well, in many cases, involve allowing the person back. Yep. Just like if a workman fixes one's shower in a deficient way, and in fact makes it worse from the original defect that made one call them in. One has a duty to mitigate, to allow the repairer to come back and have another go in most circumstances, especially if the defendant's saying, well, I just need to tweak one little.
What I was going to say, though, that these propositions don't tell us whether it's a continuing cause of action, which is our question.
Yes, my Lord, that's where I need to go now.
Because Lord Holt wasn't, I think, dealing with a case where somebody pleaded the Limitation Act, was he? The only issue was whether there was a cause of action against the claimant, the defendant at all. Yes. In relation to the obstruction of the market, or whatever it was. I'm not sure it was obstruction of the market in his case, but it certainly was in Thompson, where the claimant hadn't been around at the time of the original construction. So it wasn't, whether it's a continuing nuisance wasn't the limitation question with which we are concerned. I know you say it's not a limitation question, but
it's a cause of action question.
It wasn't a question which went to limitation consequences, I don't think, in either of those cases, so far as one can see.
No, my Lord. As far as one can see, that's so. Although that's not the position in relation to cases we're going to look at. Darley in particular, yeah. Which is based on a case called Bonamy, which we actually haven't got, but I'll explain it very briefly. So, my Lord, what we therefore say is, in our case, Shell created the nuisance and in a straightforward and direct way caused the interference with the claimant's land, which did in fact occur. What it abated was the source of the nuisance, namely the ruptured flow line. That doesn't help them when they created the nuisance because they're already directly liable. And that's the legal context. Now, my Lord, before going on to, I've got to set the legal context. Before going on to continuing nuisance, I do need to say a word or two about fault in the law of nuisance. Because the prima facie position is that if it's established that there's been a substantial interference with the claimant's use of land caused by an action or sometimes a failure to act on the part of the defendant, liability is strict. Although the courts have developed two important glosses on that. The authority for the strict liability is a case called Reed and Lyons. It's an explosion case. It's also, which is cited in Hunter and Canary Wharf. I mentioned it only because fault is obviously important, but one of the justifications for liability being strict is, of course, that the focus in nuisance must always be not on the conduct of the defendant, that's a negligence thing, but on the harm to the claimant. And the two glosses on that, which your lordships will of course be familiar with, which are important, are the principle of reasonable user. That was evident in a recent case in this court of Fern and Tate, the principle of give and take, live and let live. And it's particularly pertinent in a case called Cambridge Water, which is at page 3243. And the passage is at page 3278.
Was Reed and Lyons not concerned with the applicability of the rule in Rylands and Fletcher? Hence, obviously, there would be strict liability if it had applied, but it didn't because the explosion was within and the damage was suffered within the plaintiff's land rather than beyond it.
My lord, absolutely so. It was an explosion case, Ministry of Defence. It was about Rylands and Fletcher. Rylands and Fletcher is, of course, just a subcategory of nuisance. And the passage that I was perhaps too quickly passing over is at the top of page 5106, where, looking at the position in a broader way, Lord Simon says on the second line of page 5106, for if a man commits a legal nuisance, it is no answer to his injured neighbour that he took the utmost care not to commit it. There the liability is strict, and there alone he has a lawful claim who has suffered an invasion of some proprietary or other interest in land. So my Lord's absolutely right that the ratio of the case is a Rylands and Fletcher ratio, but Lord Simons does deal with nuisance in a wider way, as one might expect in the House of Lords, Rylands and Fletcher being a subspecies of nuisance in that way. So, my Lord, where I was saying, well, yes, nuisance is strict, liability and nuisance in terms of fault is strict, but there are two important glosses on that. One is reasonable user. If your lordships look at the passage in which this is dealt in Cambridge Water and Eastern Counties, this was the case where the PCE, the solvent, spilt when it was being applied to the machinery using the tannery, and it seeped through the concrete and then 1.5 miles downstream into the defendant's water installations. My Lord, the passage is at page 3278. It's page 299 of the judgment, where Lord Gough says at letter D, of course, although liability for nuisances generally be regarded as strict, at least in the case of a defendant who has been responsible for the creation of a nuisance, even so, that liability has been kept under control by the principle of reasonable user, principle of give and take, as between neighbouring occupiers of land, under which those acts necessary for the common and ordinary use and occupation of land and houses may be done, if conveniently done, without subjecting those who do them to an action, Bamford and Turley. The effect is that, if the user is reasonable, the defendant will not be liable for consequent harm to his neighbour's enjoyment of his land, but if the user is not reasonable, the defendant will be liable, even though he may have exercised reasonable care. So the first gloss is that important principle of reasonable user. And the second gloss, which comes out in the same case very forcefully, is the principle of foreseeability, the requirement for foreseeability. And, my lords, we say that foreseeability was the central theme and it was the deciding factor in Cambridge Water. The crux of the issue is set out at page 3274D, page 295 of the report. It was established that the spillage of solvent on the defendant's land had caused interference with the claimant's land 1.5 miles away, And Lord Gough says there are two possible principles which would allow the defendant to escape liability. One, that the user, this is just above letter D, that the user of ECL's land resulting in the spillage was in the circumstances of a reasonable user, or two, that ECL will not be liable in the absence of reasonable foreseeability that its action may cause damage. And then the defendant did not rely on the first principle of reasonable user, and the basis upon which the judge at first instance rejected the claim of nuisance, letter E, must have derived from his finding of lack of reasonable foreseeability of damage of the relevant type. And Lord Gough upheld the decision at first instance, so in that case, the defendant wasn't liable at all because it wasn't foreseeable that the substance would interfere with the claimant's land and thus cause a nuisance. So putting it more broadly, the defendant wasn't at fault for the nuisance, notwithstanding a failure to prevent it, because the nuisance wasn't reasonably foreseeable. And the basis for disposing of the case in that way is at page 3285H. And my Lord, I'm showing your Lordship this because it's we say the respondents are misreading the case, but the disposals just above letter H. For my part, I do not consider such an argument as well-founded. Here we are faced with a situation where the substance in question, PCE, has so travelled down the drift, through the drift in the chalk aquifer, beneath ECL's premises, that it's passed beyond the control of ECL. To impose strict liability on ECL in these circumstances, either as the creator of a nuisance or under the rule in Rylands and Fletcher, on the grounds that it has subsequently become reasonably foreseeable that the PCE may, if it escapes, cause damage, appears to me to go beyond the scope of the regimes imposed under either of those two related heads of liability. This is because when ECL created the conditions which have ultimately led to the state of affairs, whether by bringing the PCE onto its land or retaining it there or using it in its tanning process, it could not possibly have foreseen that damage of the type now complained of might be caused thereby. Indeed, long before the relevant legislation came into force, the PCE had become irretrievably lost in the ground below. In such circumstances, I do not consider ECL should be under any greater liability than that imposed for negligence. So, what Lord Gough is doing here is not establishing any requirement of continuing control in the law of continuing nuisance by this passage. What he was establishing was a requirement that at the time of the act of the defendant which causes the nuisance, because it's a creation case, the harm must have been reasonably foreseeable. That is all it does. My Lords, that's the background. And it's with that background, with your Lordship's permission, that I could look at continuing nuisance, and then I just need to look at two cases, and then I'm basically done. But the two cases are important ones. And the first is Delaware Mansions, which is page 3484. And my Lords will be aware, the issue in Delaware Mansions was whether fresh causes of action accrued in favour of the claimant by reason of continuing nuisance. The same issue we have here. Delaware, the first claimant, provided maintenance and services to leaseholders of a group of terraced mansion blocks held on long leases, and cracks began to appear to the structure of 3 blocks, and engineers reported that the roots of a plane tree on adjoining premises had encroached under the property, thereby desiccating the soil. And the former freeholder, the church commissioners, sold the freehold to Flexon without any assignment of the right of action. Westminster refused to do the works, so Flexon did the works with Delaware, and sued for damages in respect of the cost of that remediation work. And the conclusion of the Court of Appeal was that the claimant had a cause of action based on continuing nuisance, and that was upheld by the House of Lords. So, my Lord, what I'd like to do is say that Delaware Mansions establishes the legal credentials of the notion of continuing nuisance, and that actually the respondent's argument that you need continuing wrongdoing completely destroys the idea of a continuing nuisance, because then it's not we're not if there has to be continued wrongdoing, it's not a continuing nuisance, it's just repeated separate nuisances creating repeated separate causes of action. And so we say that the notion of continuing nuisance, which is established in Delaware, is defeated by the respondent's analysis and made irrelevant and inapplicable in most situations. And then, to finish off, I need to take your lordships to a case of continuing nuisance which is completely inconsistent with the contention made by Shell that continued wrongdoing is required, and that's Darley.
But in both of these cases, you've still got a continuing state of affairs on the defendant's land, whereas your argument, as I understand it, is that you need a continuing nuisance, or there's a continuing nuisance simply because of the effect on the claimant's land. In other words, there's a state of affairs in Delaware on the defendant's land.
Yeah,
and I think you're going to take us to Darley where it'll be the same. Or maybe it's not.
My lord, I'm not sure it is.
Oh, okay.
I think that's why I'm using them differently. My lord, what I'm using Delaware mansions for is to seek to persuade your lordship there is an important concept called continuing nuisance.
Right.
And I accept the distinction your lordship's drawn, but in Darley, that's much closer to our facts. Much, much closer to our facts. And indeed, what I'm going to say about Darley is that the argument between the 4 law lords in the majority and the 1 in the minority, in Blackburn, is exactly the same as the argument before your lordships. It's the same point. But if we go to Darley, to Delaware.
You're not going to invite us to follow Lord Blackburn.
No, my lord, I'm not going. No, but my lord, it's one of those cases where the dissent is so important because the dissent also highlights what the majority are saying. So the key passage of Lord Cook's judgment in Delaware is at page 3496H, which is page 333 of the report. Paragraph 33 at the bottom of page 3496H. Approaching the present case in the light of those governing concepts and the judge's findings, I think there was a continuing nuisance during Flexon's ownership until at least the completion of the underpinning and the piling in July 1992. Pausing there, my lords, Flexon took over in 1990. It matters not that further cracking of the superstructure may not have occurred after March 1990. The encroachment of the roots was causing continuing damage to the land by dehydrating the soil and inhibiting rehydration. Damage consisting of impairment of the load-bearing qualities of residential land is, in my view, itself a nuisance. This is consistent with the opinions of Mr. Justice Talbot and Masters, the Court of Appeal in the instant case, although neither Mr. Justice Talbot nor Lord Justice Pill analysed specifically what they regarded as a continuing nuisance. Cracking in the building was consequential. In regard to the proximity of the plane tree to Delaware mansions, a real risk of damage to the land and the foundations was foreseeable on the part of Westminster, as in effect the judge found. So there's the foreseeability gloss on strict liability. It's arguable that the cost of repairs to the cracking could have been recovered as soon as it became manifest. That point need not be decided. But that's redolent of my Lord Sale's question. Although I'm disposed to think that a reasonable landlord would notify the controlling local authority or neighbour as soon as tree root damage was suspected. It is agreed that if the plane tree had been removed, the need to underpin would have been avoided, and the total cost of repair would have been only £14,000.
That may be an important aspect of the reasoning in the case, because at any point the cause of the continuing damage could have been prevented by the defendant.
My Lord, we say it's not.
Had the plane tree been removed, the need to underpin would have been avoided, and the total cost of repair would have been limited to only £14,000.
It would have been less. But that doesn't mean it's not a continuing nuisance.
It is a continuing nuisance, but because the tree is continuing to live, and that living tree is causing the damage, and it is the desiccation caused by the living tree that is causing new damage every day.
As the root system grows and becomes more extensive, there's more and more.
It's not the roots alone which cause the damage, it's the water abstraction going on during the summer months.
But my Lord, that's
leaves on the tree.
That's
sucks up water through the roots.
Yes, it's the encroachment of the roots causing continuing damage to the land by dehydrating the soil.
Yes. Yeah. If you chop the tree down, then that'll stop, because the roots will stop drawing water from the neighbour's land.
My Lord, but it's not. That doesn't appear to be the basis upon which the decision is made.
Well, with respect, it is the basis upon which the decision is made, isn't it? Because of that particular sentence I'm drawing your attention to. That's a pretty fundamental aspect to the reasoning.
And previously, in that same paragraph, Lord Cook says, he refers to the problem of dehydration of the soil and says damage consisting of impairment of the load-bearing qualities is itself a nuisance. I mean, the cracking follows on from that, but the nuisance is the dehydration in the soil, isn't it?
My Lord, what we say about this is that the focus of analysis has always got to be on what happened on the claimant's land. The continuing nuisance was the harm to the land caused by the tree roots. The tree roots are equivalent in our case to the slick, the moving oil slick. And the tree is equivalent to the pipe.
Well, they are to a point, but there is a difference too, and an important difference, because the continuing damage, the new damage, is caused by the further desiccation. And that could be prevented by the defendant chopping the tree down, or presumably cutting its branches back, and in the way that one commonly sees take place on the roads of every city every year.
But my Lord, from the parts of paragraph 33 that I read out, it looks like the basis for the liability is not the defendant's ability to abate the source of the nuisance by chopping down the tree. The basis of the liability is the damage caused on a continuing basis by those tree roots, by the tree roots sucking the water out of the land. This passage that my Lord looks at, which also was looked at by Lord Justice Coulson, is simply noting the agreement between the parties that the damage would have been less if something had been done earlier. But it's not the finding of the basis of liability.
Can I just ask about this analogy between the moving oil slick and the roots? Because I think this goes back to the question I asked you some time ago.
Yes.
The Delaware Mansions is based, it's a continuing nuisance because at least on your approach, the damage is ever changing because the roots are always creeping along, and therefore the soil that's being dehydrated is going to be changing day to day. Now, I was pressing you on whether you were saying that that was the same on the facts of this case. Are you saying that the oil is ever changing damage?
Well,
is it actually equivalent to the tree roots? Let's leave aside the additional issues about who's got control or who hasn't got control. I'm just now focusing entirely on the effect on the claimant's land. And I'm just asking, the clear point about a continuing nuisance here is that the tree roots are creeping and there's different damage day in, day out.
There's recurring different damage, that's all.
Yeah. Okay, recurring different damage. Now, is it your case that there's recurring different damage in our case?
Yes, because the oil slick and the roots have got in common mobility. They move. And as they move, they cause different damage to different parts of the soil or land.
Mr. Siegler, you very helpfully encapsulated the issue before us at the very beginning of your submissions, and you said the issue is, can a defendant in principle be can be liable for continuous interference where its acts have caused a continuing harm, or must there be continuing wrongdoing by act or control plus failure to act? I mean, anyone looking at paragraph 33 of Delaware Mansions would think that Lord Cook was saying it was foreseeable to the council that for as long as it was in control, after all, it was in control and had authority to cut down the plane tree. Whether or not it was actually the landowner, I don't think matters. But it was foreseeable that every day that tree remained there, or at least every summer day the tree remained there, there would be further damage caused by the thing called the tree plus its encroaching roots. And since that was foreseeable, and since the council had the power to cut it down, in which case the roots would cease to cause anybody any problem, they were liable. In other words, looking at the case, it was a case where there was continuing wrongdoing. The wrongdoing being the failure to abate an existing state of affairs, which was both foreseeable and within the defendant's control. I'm not saying it's a case against you, but I'm not sure why it's a case which answers the question which you started with in your favour.
My Lord, my Lord's absolutely right, but that's why I said I'm using Delaware to show you Lordships there is such a thing as continuing nuisance, but using Darley to show that you don't need continuing wrongdoing or control. My Lord, what I've been trying to do is to take your Lordships step by step through the analysis, and the significance of this case is, well, first of all, we have the sentence at the bottom of the page we're on, 3496, which is damage consisting of impairment of the load-bearing qualities of residential land is, in my view, itself a nuisance. So the harm is the nuisance. The nuisance was the moving roots, which took away water from the soil.
And so I just wanted to pick you up on that. I mean, I'm not sure that it's the mobility of the roots which is being talked about there. I mean, once you've got the roots there, I mean, okay, they've moved there, but it's the same roots in the same metre squared of land that's still sucking up water from that land. So it didn't seem to me that mobility was the key.
My Lord, it's the mobility. My Lord, it's the mobility which creates the different damage, because the roots don't just suck water from the soil that they're in, but they also move, increase, and therefore suck water from different soil tomorrow
Right.
than they did today.
But I mean, they're sucking water even from the land. They're still sucking water from the land that they're in. So they're making the problem worse even for that bit of land, aren't they?
They are. To that extent, but also different damage is being created in addition. So, well,
Can you, at some stage, take me to where you've articulated that this is recurring different damage?
where I've articulated...
Yes, I think you said it's in your pleadings.
Yes, it's...
Yeah.
It's,
which when Lord Justice Coulson looked at it,
yeah.
didn't seem to think that that's, as I understood it, what was being said.
It's paragraphs 58 and 59 of the original petition.
I mean, I don't want to take you out of your course now. If you just give me the references.
The references are paragraphs 58 and 59 of the original particulars of claim. The original particulars of claim are at page 1049.
And your response to Lord Justice Coulson is what? That he's just...
Sorry, which paragraph?
58, 59.
There's page, it ends 073.
So, paragraph, they're both written in the present tense. So, the 58 says that oil spills have caused pollution and contaminated the ground and drinking water. 59 says the wood from the mangrove forest is now covered in oil and unsuitable. The claimants are therefore having to find and utilise more expensive sources of energy. So what it's saying is that each day that the oil remains on the land unremediated, they are incurring fresh loss every day that they can't use their wells, and they've got to buy drinking water, and every day they can't burn tainted mangrove wood and have to buy alternative fuel. That's what it's saying.
But that's not the same as recurring different damage. If I knock down your house or there's an explosion that destroys your house, every day you are without your house, but though nobody would suggest that that's a continuing nuisance. The house is damaged, has been destroyed on day one.
Yes.
So what we need is something clear about the recurrent, fresh damage, and I don't see this in the particulars that you've pointed us to. That's just the continuing effect of one item of damage is covered also by what you've here specified, as I see it. And I think that's what Lord Justice Coulson may have been saying.
Well, Lord, I'm going to take that away. I wonder if that's a convenient moment.
Yes, certainly. During the short adjournment, parties might want to discuss the implications of the time that was taken up with submissions first thing this morning.